Good morning to one and all. I'm Shivangi Singh, Assistant Professor, School of Law, Sharda University. Today we have gathered to pay tribute to the father of the Indian Constitution, Bharat Ratna, Dr. B.R. Ambedkar, through a talk on review of working of the Constitution of India. On behalf of School of Law, I wish to extend a warm welcome to our distinguished guests and thank you to all the attendees. Today we have amongst us Professor Kamala Sankaran ma'am. Professor Kamala ma'am is currently a professor of law at the Campus Law Center, Faculty of Law, University of Delhi. Her research interests include constitutional law, international labor standards, and the regulation of work. Her recent books include Affirmative Action, A View from the Global South, and Challenging the Legal Boundaries of Work Regulation. Professor Sankaran ma'am has previously served as the Vice-chancellor, Tamil Nadu National Law University. She has been a fellow Stellenbosch Institute of Advanced Studies, South Africa, visiting South Asian Research Fellow, School of Interdisciplinary Area Studies, Oxford University, and a visiting scholar and a recipient of Fulbright Postdoctoral Fellowship at the Georgetown University Law Center, Washington, D.C. She is a member of International Advisory Board, International Journal of Comparative Labor Law and Industrial Relations, member of Editorial Board, University of Oxford Human Rights Hub General, member Editorial Advisory Board, Indian Journal of Labor Economics. Now I will like to request Dr. Avinash Sir, Assistant Professor, School of Law, to welcome our dignitary guest.
Thank you, ma'am. Good morning to all and all present here. Respected Professor Kamala Sankaran ma'am, Professor Pradeep Pulsar sir, dear colleagues and students, I, Dr. Avinash, take this opportunity on my behalf and on behalf of Professor Pradeep Pulsar sir, Head and Dean, School of Law, Sharda University, the management, faculty, non-teaching staff, and the students to start this auspicious talk by heartily welcome everybody. I heartily welcome our chief guest, our dean sir, my colleagues, and dear students. Today we have gathered here for a talk on a review of working of the Constitution of India on the occasion of tribute to the father of Indian Constitution, Bharat Ratna Dr. Bhim Rao Ambedkar sir. I appreciate and thank you each and everyone who put equal efforts into the success of our school. In the light of our experience of past 50 years as to how the best the Constitution has responded to the changing needs of an efficient, smooth, and the efficient system of the governance and socio-economic development of the country, to recommend changes that are required in the provisions of the Constitution without interfering with its basic structure or basic features, was assessed by the National Commission to review the workings of the Constitution headed by Justice Venkat Chalaiya. The committee submitted its report in the year 2002. About 2 decades have passed and nothing substantial could be done. The reports submitted by the commission were not worked out properly. Hence, this program has been organized to make the students and scholars learn the required changes in the provisions of the Constitution, if any. The speaker is an authority on the constitutional law. She will be sharing her expert opinion and views on this contemporary topic. If we take two names, Professor Madhav Menon sir and Professor Upender Bakshi sir, to whom all of us respect, although I am at a very young age, I dare to say Professor Kamala Sankaran ma'am is in the making of becoming the one. We would like to honor our chief guest, Professor Kamala Sankaran ma'am, and invite her to share her visionary thoughts along with an expert opinion. Once again, I welcome you all. Thank you.
Good morning to everybody, and I thank the Dean, School of Law at Sharda University, Professor Pradeep Kulsresht, Dr. Avinash Kumar, Ms. Shivangi Singh, and other faculty members for this invitation to speak in your program today that's titled A Tribute to the Father of the Indian Constitution, Bharat Ratna Dr. B.R. Ambedkar, and to review the working of the Indian Constitution. It's a privilege to speak on this occasion and present some of my ideas on this subject. Let me also say this is the first time I've interacted with Sharda University, and I'm very happy to be here this morning. And I noticed that there are many students also who have logged into this program. So, my good morning to all the students and other members present here. Dr. Bhimrao Ramji Ambedkar, who was also the chairman of the drafting committee of the Constitution of India, has rightly been called a polymath who wrote and spoke on subjects as varied as history, law, philosophy, and economics. But those varied and deep interests alone do not describe the man. Dr. Ambedkar was also an organizer, a person who galvanized so many of his fellow Indians to stand up and fight for their rights and to fight for change. Recall the Mahad agitation for the right to drinking water. This is just one example of this very multifaceted person we are proud to call as the chairman of the drafting committee of the Indian Constitution. The words that Karl Marx wrote almost 200 years ago in his thesis on Feuerbach, and he said, and I quote, "Philosophers have hitherto only interpreted the world in various ways. The point is to change it." And these, according to me, would be words that can be used to describe Dr. Ambedkar, who was at the very same time a thinker as well as a man of action. And that's something that I think young students who are studying law, we don't study only for our personal glory. We study because we want to use the law to change things that we want to see in society. So I tell young students who are present here this morning that it is worthwhile to look at the lives and times of people like Dr. Ambedkar to understand and to make for yourself the kind of trajectory that you would like your life to have. Now come back to the Indian Constitution. The drafting of the Indian Constitution was a process spread over 3 years, we all know that saw very contentious ideas being put forward and being debated. And despite the very turbulent backdrop of the unfolding partition of India, what was remarkable was the form and the manner in which ideas were expressed within the Constituent Assembly. The debates in our Constituent Assembly exemplified all the virtues of patient consideration and discussion, which should typify a genuine debate. Remember that the Indian genius of the argumentative Indian, as Amartya Sen reminds us, doesn't necessarily mean an angry Indian, an argumentative Indian. And I urge all of the students who are present here this morning to read these constitutional law debates. And like me, I think you will share the same emotion when you read it, that we can look back and wonder that such calm deliberation was ever possible in that grand central hall of Parliament. And speaking at the conclusion of the debate for the adoption of the draft constitution on the 25th of November 1949, well before you were born, well before even people like me were born, okay, all those years ago, Dr. Ambedkar remarked on the courtesy and the consideration that was shown by various members during the debate. And he also pointed out that but for these debates, and I quote, "I would not have had the opportunity which I got for expounding the principles underlying the Constitution, which was more important than the mere mechanical work of passing this Constitution." End quote. So this morning, as part of this program, I want to briefly trace what these quote unquote underlying principles that Dr. Ambedkar referred to, how these draw upon principles of what I term democratic constitutionalism, which was developing in a post-Second World War world, and with it, the new respect for human rights. And then I would like to trace some of the ways in which the constitutional amendments and judicial interpretation these past 70 odd years have deepened these underlying principles which were highlighted by Dr. Ambedkar in the process of drafting the constitution. That's really what I hope to do over the next 30 minutes or so. These principles, these underlying principles, primarily find their reflection in the preamble of the Constitution, as well as the key choices that were made by the Constituent Assembly regarding the form of government, the type of institutions that were opted for in the new Constitution, etc. What is of interest to law students is that many of these principles expounded by Dr. Ambedkar during his numerous speeches in the Constituent Assembly, as well as further elaborated in his numerous writings outside the Constituent Assembly, these same principles were also reflected in what the Supreme Court subsequently identified as basic features of the Constitution in the well-celebrated Keshwananda Bharati case much later in 1973. So you see these links that we get formed over our constitutional history, and I think it will be very interesting for students to cast their mind back and forth in order to understand the true contribution of Dr. Ambedkar, and that we don't confine him only to the 46-49 period, but we see many of his thoughts being linked through in these past 70 years. I first take up democratic constitutionalism. Most countries in the world today have a written constitution, whatever be its content or political moorings. The notion of constitutionalism, as it has evolved over the past century, focus on a set of features considered necessary in any constitution to ensure the specific outcomes of creating a democratic polity and society. This is a form of democratic constitutionalism, if you will. Several authors have identified these ingredients of a liberal democratic constitution as it emerged in the countries of the global north, which were born after the American and French revolutions of the 18th century. And these ideas had been put forward as a necessary precondition for a good society or as necessary for advancing the common good. These ideas are then received notions of constitutionalism that have then been borrowed by the post-colonial countries of the global south, meaning the countries of Asia, Africa, and Latin America that were newly emergent post-colonial societies in the mid-50s of the past century that threw off the yoke of colonialism following the Second World War. Many of these ideas resonated in our own Constituent Assembly, and what is interesting is that they were readily adopted within India. The idea of outside, inside, is this a foreign, is it national, was not there. I think the idea of Tagore, that let all the winds of the world and breeze of the world whirl through my own room, I think the Constituent Assembly was fully imbued with those views. Now, what were some of these features of democratic constitutionalism? Let me just list them a little briefly. First, the guaranteeing of individual rights or a set of entrenched rights against a growingly powerful state that was set to emerge in the post-Second World War period. Whether we subscribe to an idea of a mythical social contract sometime in humans' historical past and treat these as entrenched natural rights retained by the people, or arrive at these rights as qualities inherent and basic for any individual flourishing, this form of ring fencing or entrenching of these basic rights in a constitution is seen as a necessary condition to level the playing field between human and human and between human and the state. The prime place given to individual liberties in our constitution, as distinct from freedom and independence for the country or the polity as a whole. And I think this is quite an important distinction to keep in mind, that the values of independence and freedom are quite distinct from the values of individual liberties or personal liberties, was almost unanimously treated as an essential principle while drafting the Constitution. Individual liberties were important not only for creating a better society, but to ensure the dignity of an individual, particularly in India, which is caste ridden, which is full of diversity based on religion and language, such as ours. And Dr. Ambedkar was one of the keenest and sharpest voices to defend the need for individual rights within the Constituent Assembly. Next, another feature is a democratic form of government based on some form of a popularly elected government. And that once elected, you are not always elected. Once elected, the elected mandate will be valid only for a finite period. 5 years is the years chosen by our Constituent Assembly. So no mandate of anybody ever lasts forever. And that is something that we must remind ourselves. That is, representative democracy would need to legitimize itself at regular intervals in order for the civil and political rights of the citizen to have some relevance. The emphasis on individual liberties, therefore, laid the foundation for a universal adult franchise that was adopted in our Constituent Assembly. Third, some system of checks and balances of institutions of governance, often identified as separation of powers, such as that the holder of office in one organ, that is, it could be the legislature or the judiciary or the executive, does not simultaneously or should not be permitted simultaneously to hold office in another arm of government, or does not interfere in the exercises of power elsewhere. So, of course, we have had people who have once adorned the bench but then went on to also stand for executive positions or governor's posts. But simultaneously, this has not been so. In fact, just yesterday, to my own students of constitutional law at the faculty, I was mentioning to them about the remarkable persona of Justice Krishnaiyer, who, of course, his last avatar was as a judge of the Supreme Court of India. But prior to that, in that very important EMS Namboodiripad government of Kerala in the 1950s, he was an independent MLA, and he also had held the office of a Minister of Law and Justice and Prison Reforms. And so, serving on the executive and the legislature and the judiciary, I think gives you a bird's eye view of everything that is happening in India. And it comes as no surprise, therefore, that many law students would choose either the judiciary or politics or civil services as their future course of action, because I think legal education gives you the equipment necessary to excel in any of these three branches of the government, but not simultaneously, as separation of powers tells us. And the Westminster system of fusion of powers adopted by our Constitution, with the executive also a part of and accountable to the Parliament, is of course one unique version of this constitutional design or template. Next, in the specific form of diversity obtaining in India, a federal state was readily accepted as one of the obvious ways to cope with diversity. And Dr. Ambedkar himself, who had studied one in Columbia University, and as you all know, he also did his PhD in the London School of Economics, where he was also familiarized himself with the Westminster model. And you see elements of in separation of powers, rejection of the strict separation of powers, veering more to a Westminster system of fusion of powers, and in other aspects of the Constitution, such as the basic liberties, very much adopting a written, entrenched Bill of Rights. So he drew upon all his personal experiences, apart from the experiences of other countries, which were, of course, very much there. But coming back to this fourth feature, that a federal setup was seen as best suited to address the regional linguistic diversity in India, yet with a strong centralizing impetus. And as political commentators have noted, prior to Indian independence, all the major parties had put forward their vision for the future, and almost unanimously, this comprised a mixture of a federal formula as the best suited to manage ethnic and national diversities within India and within states. Next, the rule of law. Now, the rule of law could be understood in two senses. In its narrow or thin conception, as a rule based system, with the rules of the game or the laws being promulgated and published in advance, so that there is no chance of a secret law, no chance of a law being contrary to another earlier law, and all these features of a narrow conception of rule of law as being contrary to the whimsical or arbitrary or capricious ruler in Lon Fuller's wonderful tale of Rex, of which he writes in his book Morality of Law, and which I hope students will have an occasion over their 5 years to read. This minimum conception of legality and rule of law was definitely a component that India borrowed freely from the global north. Next, fifth, to keep these institutions in check, a designated authority, and which India chose as the judiciary, to exercise the power of a constitutional court, to interpret the constitution and hold all other institutions to account, and to operate within the areas of remit with no overreach. Article 32, therefore, as the site of judicial review, was termed by Dr. Ambedkar as the very soul of the Constitution. And in short, what we notice over these past 70 years is that judicial review marks the emergence of the growing importance of the courts and the growing influence of what Alexander Bickel called the least dangerous branch of the government. Finally, all these aspects were to be contained in a constitution in order to ensure a liberal society and a democratic society. And so India borrowed these principles of democratic constitutionalism. Eventually, therefore, what was the choice we made in our own constitutional design? These principles underlying the constitution, which is the phrase used by Dr. Ambedkar that I quoted earlier, oftentimes appear inadequate in a country such as a newly independent country or a developing country such as India, ravaged by growing inequality and strife. Remember that the trinity of rights put forward 200 years ago in the early Constitution of the United States highlighted life, liberty, and property, but it did not mention equality or social justice. Therefore, the framers of the Indian Constitution, as evidenced in its preamble, made a definitive choice, what we call a pre-selection, that highlighted justice. That was placed right up on top in our preamble. Justice, social, economic, and political, as well as equality of status and opportunity, which were as important as liberty and fraternity. The preamble to the Constitution and its provisions did not present the question as a trade off between liberty and equality or between liberty and basic needs. Instead, it chose to pursue the goals of justice and liberty and equality and fraternity simultaneously and not privilege one over the other. And that, I think, is something that we must keep in mind as we go along this constitutional journey. Now, Dr. Ambedkar, in his speech in the Constituent Assembly, spoke about the need to remain steadfast to these goals laid out in the preamble. He said, and I quote, "We must not be content with mere political democracy. We must make our political democracy a social democracy as well. Political democracy cannot last unless there lies at the base of it social democracy." What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity as the principles of life. These principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. End quote. He spoke this actually on the final day when the draft constitution was being debated and was about to be voted upon. Let me now come to the idea of social justice and equality as developed in the Constitution by many others, including Dr. Ambedkar, as well as the developments in our own Constitution through amendments and judicial decisions. John Rawls, in his book Theory of Justice, identifies justice as the foremost virtue among all social institutions. There is no doubt in his mind. Above liberty, equality, fraternity stood justice. And I think, of course, John Rawls wrote this book in 73, but our own preamble does the same ranking. Justice is right up on top. If justice is the wellspring from which other values flow, it is not surprising that modern thought seeks to find a link between equality and justice. What's that link? The need to treat each person as an equal, not only in a formal way, but also as Ronald Dworkin states in his book and his essay, Taking Rights Seriously, as entitled to equal concern and respect. That each human being is entitled to equal concern and respect requires that the state must treat each person with equal concern, taking their situation into account, and simultaneously accord equal respect and dignity to each individual irrespective of the situation. This is a duty therefore cast upon the state. So the preamble of our constitution, to our constitution, balances on the one hand justice, which has long been identified in Western philosophy as one of the four cardinal virtues of prudence, justice, temperance, and fortitude, alongside on the other hand, more modern concepts of liberty, equality, and fraternity, which of course, was the banner inscribed on the French Revolution. Yet Dr. Ambedkar's notion of equality was therefore, combining it with the idea of justice, was much more complex than the flat notion of, or the flat enunciation of treating equals equally or as one of formal equality that we find in the initial phases of the First French Republic and the American Constitution. Using the prism of justice, he contextualized equality as it obtained in the reality of India with its caste divisions and centuries old caste discrimination and prejudice. And he talked of the reality of India of graded inequality. And this, according to my mind, is a very valuable theoretical contribution of Dr. Ambedkar. Now, what is graded inequality? I'm going to quote from the 2008 Supreme Court judgment in Ashok Kumar Thakur versus Union of India, where Chief Justice Balakrishnan, in his judgment, in his lead judgment in this case, quoted from Dr. Ambedkar's speech in the Constituent Assembly, and I quote, "We must begin by acknowledging the fact that there is complete absence of two things in Indian society. One of these is equality. On the social plane, we have in India a society based on the principle of graded inequality, which means elevation for some and degradation for others. And on the economic plane, we have a society in which there are some who have immense wealth against many others who live in abject poverty. End quote. And as if for those of you who read Dr. Ambedkar's Annihilation of Caste, you will realize that his idea of graded inequality is that unlike an idea of just two broad classes of rich and poor, or the bourgeoisie and the proletariat, the caste division allows each so-called upper caste to discriminate against the caste lower to it. And therefore, you have this system of graded inequality. And therefore, you need to, as he put it, actually completely annihilate caste if you want to do away with this invidious form of graded inequality. Now, long before the phrase came into popular use, Dr. Ambedkar had successfully incorporated the concept of substantive equality into our constitution. Now, what do I mean by this? The formal equality merely says treat everybody equally, unmindful of what their economic reality is and unmindful of what the social reality is. You just look at a person and you don't look behind the person to see is he rich or poor, is what caste does he belong to. You just look at that. But that's not adequate in India, where we have graded inequality and we have great differences between rich and poor. Substantive equality, which is a phrase we use today, is something that, in my understanding, Dr. Ambedkar had successfully used many years ago. And while confronting the need to provide for liberty, equality, justice, fraternity, and dignity, it influenced the ultimate constitutional choice in which he played a great part. And this constitutional choice inevitably leads us to the kind of design that places duties upon the state. And this marks a definite break from the earlier constitutions cited in the debate. No longer can we speak of a state that only respects individual rights and whose only task was that they should not interfere. Instead, our constitution places positive duties upon the state, which the state is under a duty to provide. Some aspects of this transition from this formal to substantive equality, or this transition which is sometimes called also a transition from a thin conception to a thicker conception of rule of law and constitutionalism, merits a little bit of consideration. The demand for social justice is partly manifested in the provisions which enable the state to make special provisions for reservation as one possible means to ensure equality in public employment or public education. The abolition of untouchability, the provisions pertaining to gender equality, the rights of linguistic and religious minority, in order that to deal with the numerical calculations of democratic politics, etc., these rights, which are also embedded in our constitutions, are examples of this thicker version of constitutionalism, which is expressly needed in our society. As the political philosopher Nancy Fraser reminds us, social justice is not only about redistribution, but it is also about recognition. The rights of communities who have been hitherto made invisible or invisibilized is to be acknowledged, and their rights are to be treated with equality and dignity. And this requires the state to do something more in order to level the playing field and to have a formal equality provision. And therefore, substantive equality is needed as a prior step before we can administer formal equality. And Dr. Ambedkar's role in drafting these constitutional provisions played a central role in this regard. In the recent Sabarimala temple entry judgment of 2018, the prohibition against untouchability, which had been incorporated in Article 17, was extended to the question of gender also. And the exclusion of women of a certain age from entry into temples was declared by at least two of the judges of the Supreme Court as an instance of the practice of untouchability. And therefore, you find that these ideas have traction in today's world and have been reinterpreted in fresher and newer ways. The Constitution of India 1950 reserves seats in government jobs for backward classes of citizens, which, in the opinion of the state, is not adequately represented in government services. The backward classes, as you know, are deemed to comprise scheduled castes, scheduled tribes, and other backward classes. The Constitution also permits the state to make special provisions in all policy related fields for socially and educationally backward classes, women, and children. The then newly adopted constitution also set aside certain electoral seats in parliament and state level legislatures for scheduled castes and scheduled tribes alone, but this was done in proportion to their presence in their constitution. All these measures were clearly aimed at including previously marginalized groups through accommodation in the state, in the government, in the parliament, etc. Transforming the nature of the legislature and bureaucracy and making it more representative was considered to be critical in making the polity more responsive to the needs of what were initially in the Constituent Assembly termed as minorities. We can note that these initial provisions focused upon the state and the measures that the state could take to achieve equality. This was done by reading an expanded scope for the term state in Article 12 so as to bring more instrumentalities and authorities within the reach of citizens and their need for justice. Yet, with the massive growth in the private sector, including in the educational sphere, these past 30 years, the court and constitutional amendments have focused on another technique to achieve a greater reach for the enjoyment of basic equality. And this is something that has been done in a post-Ambedkar, Dr. Ambedkar period. In the recent past, we have seen that the mandate of equality has been developed not merely against the state, but even against private persons. This horizontal, rather than the traditional vertical application of the right to achieve equality, is seen in the insertion of Clause 15, Clause 5, Subclause 5, and 15, Subclause 6, introduced recently, that empowers the state to make a law which in turn can mandate even unaided private educational institutions to make special provisions for socially and educationally backward classes of citizens or for economically weaker sections in private unaided educational institutions. So this is a new development which makes caste duty not only upon the state, but is casting duties also on private players. And therefore, you move from the traditional vertical to now a more horizontal application of these rights. Thus, we have an imagery of the sword and the shield, which we actually borrow from American constitutional law. The rights which are given to individuals are seen as swords to be used against the mighty state. And at the same time, the directive principles in Part 4, along with certain duties or powers located in Part 3, I refer here to the power of the court under Article 32, as well as the enabling power of the state to have affirmative action in Articles 15, 16, 29, etc., or the power to abolish untouchability or begar in Articles 17 and 23. I refer to all of these compendiously as a shield to be used by the state for its programmatic policies. So no challenge lies against the state for its proactive steps or affirmative steps to bring about equality. And this is unlike the American Constitution. And that's a unique feature of our constitution, which in turn has now been borrowed by many other more recent constitutions. I draw your attention to the South African Constitution of 1996, which drew a great deal upon the structure of the sword and shield in our Constitution. It is for this reason that our Constitution is conceived not just as a sword against state domination or against the violation of historic civil society norms and practices, but also as a shield empowering the state to intervene by law and policy to transform society, hopefully in a progressive manner. Rights and duties cast upon persons as well as the state. Coming now to liberties. We can note that liberties in our Constitution have not been granted in absolute terms. The history is fairly well documented in the literature, and I'm sure many of you have been reading these new rush of books and articles that have come on constitutional history of how Sri B.N. Rao, constitutional advisor, met Justice Frankfurter, who advised him against following the path of the US Constitution, which through its amendments guaranteeing rights in seemingly absolute terms, yet required the US courts to step in by using the doctrine of police powers to justify certain limitations to be placed on what at first blush appears to be absolute rights. In the drafting committee, there was complete consensus that we must not only have a set of liberties, but these liberties must be tempered with the power given to the state to impose reasonable restrictions through lawful means. Article 19 is a good example of this. Article 19, with its assertion of individual freedoms on the one hand, with its granting of a Hofeldian power, I'm drawing on Hofeld, power to the state, with the power to the state to impose restrictions on this right, perhaps best typifies this balancing approach. Thus, I would submit that the doctrine of proportionality appears as an inbuilt feature in our Constitution rather than a set of only judicially crafted principles, which is how it appears in so many jurisdictions across the world. So, my submission is that proportionality is hardwired and inbuilt in the way in which our rights and liberties have been structured. Yet, the court too in India has had to consider how best to achieve such a balance. While the balance seems to be there in the text of the Constitution, how best to develop this has been. Consider, for example, the view of Chief Justice Patanjali Shastri in the 5-judge bench of the Supreme Court in State of Madras versus V.G. Rao of 1952, who laid down what could be termed reasonable in any given case. The court acknowledged that in evaluating what could be termed reasonable restrictions, it had to be dictated by the sobering reflection that the Constitution is meant not only for people of their own way of thinking, but for all, and that majority of the elected representatives of the people have, in authorizing the imposition of these restrictions, considered them to be reasonable. One of the well-known legal philosophers of our time, Ronald Dworkin, in his book Taking Rights Seriously, notes that the concept of a right implies its ability to trump or prevail over a public good. That is, rights apply in, as he put it, an all or nothing fashion. Yet the structure of Part 3 of our Constitution that guarantees certain basic rights and also provides the grounds for restricting these rights, does not grant absolute rights, as we have just noticed. In the recent Anuradha Bhasin case, dealing with internet freedom in Jammu and Kashmir after the abrogation of Article 370, the Supreme Court drew upon the discussion of the doctrine of proportionality in the Puttaswamy case, in the modern dental college case, and in the Puttaswamy 2 case, and noted that the idea of rights as trumps, as indicated by Dworkin, was only one view. There is an alternative view held by Robert Alexie, wherein the fundamental rights are viewed not as rights but as principles. Unlike rules which operate in an all or nothing fashion, principles are norms which require that they be realized to the greatest extent possible given their legal and factual possibilities. So you do not say that these Article 19 rights will always prevail. They will be realized to the extent possible. This means that when they conflict, one principle has to be weighed against the other, and this is the nature of a principle that implies the principle of proportionality. One of the biggest challenges of our current time is to achieve a correct balance between the power of an individual against the state or between conflicting set of rights amongst people or groups. And while the doctrine of proportionality does provide a mechanism to weigh these two competing principles, ultimately what we have to remember is that the choice will depend on our political and social outlook that we have for the future of India, and the primacy one places on individual liberties. That is, at the end of the day, even the constitution always comes back to political choices that we must make. So to look at it only as a legal document, as one of a judicial crafted document, would be a very erroneous one. And this is not the way that Dr. Ambedkar, for instance, ever looked at the constitution. When we move from the constitution as adopted and amended to its interpretation and development over these past 71 years, what is perhaps unique in India is that these basic principles discussed, that I just discussed, are not or need not be merely located in the constitutional text. Various broad principles and constitutional values that underpin the constitution have been identified by the Supreme Court and are now entrenched in a different manner, not in the text but differently. These features stand entrenched in the underlying basic structure or the essential features of our constitution following the Keshwananda Bharati judgment delivered in 1973. Thus, the movement towards ensuring a thicker version of constitutionalism is one carried out not by the parliament but by the court. This entrenchment of basic structure or basic features has been a milestone of constitutionalism as developed in India. And if you look at this 11 separate judgments delivered in the Keshwananda Bharati judgment, it indicates the pivotal role played by the preamble, part 3 and part 4, in shaping what would be the basic aspects of the constitution. Justice Beg, in that Keshwananda Bharati judgment stated, and I quote, "I think it is clear from the preamble as well as the provisions of part 3 and part 4 of our constitution that it seeks to express the principle Salus Populi Suprema Lex. In other words, the good of the mass of citizens of our country is the supreme law embodied in our constitution, prefaced as it is by the preamble or the key which puts justice, social, economic and political as the first of the 4 objectives of the constitution, by means of which the people of India are constituted into a sovereign democratic republic." And other judges, including Chief Justice Sikri, identified supremacy of the Constitution, republicanism, democratic form of government, secular character of the Constitution, the separation of powers, and the federal character of the Constitution as part of the basic structure. Excuse me. Subsequent cases have identified the rule of law, equality, judicial review, and more recently, the Supreme Court in the M. Nagaraj case identified egalitarian equality, which, if you look further, looks very much like substantive equality as a key feature and part of the basic structure. The idea of egalitarian equality raises the question of what duty is cast upon a state that I mentioned earlier. While the political process and electoral accountability may nudge the legislature, it continues to remain the province of the court in exercise of judicial review to monitor that basic features do not get left behind in the race to become a country that counts in the world. Dr. Chandrachud, as I'm now winding down my talk, I'll refer to Dr. Justice Chandrachud, who in the Pittuswamy 1 judgment explained why continuous interpretation makes our constitution a living document and resonates so much with what Dr. Ambedkar said all those years ago. And that living constitution is what gives the link between today and our past. And in his words, in the words of Dr. Justice Chandrachud, quote, we describe the Constitution as a living instrument simply for the reason that while it is a document which enunciates eternal values for Indian society, it possesses the resilience necessary to ensure its continued relevance. Its continued relevance lies precisely in its ability to allow succeeding generations to apply the principles on which it has been founded to find innovative solutions to intractable problems of their times. The learned judge went on to say, and in a manner very reminiscent of Dr. Ambedkar, that constitutionally protected rights embody the liberal belief that personal liberties of the individual are so sacrosanct that it is necessary to ensconce them in a protective shell that places them beyond the pale of ordinary legislation and places them beyond the pale of legislative majorities. This is so reminiscent of what Dr. Ambedkar spoke of in the Constituent Assembly when he emphasized the need for justice, to achieve equality, and the enjoyment of liberties equally by all. And he stated, quote, fraternity means a sense of common brotherhood of all Indians, of Indian being one people. It is the principle that which gives unity and solidarity to social life. Thus, these key principles that Dr. Ambedkar had elucidated continue to be the bedrock on which any just and progressive future of India can be built. And occasions as this tribute, today's tribute to Dr. Ambedkar, afford a powerful reminder to us to reinforce what he termed as these principles underlying the Constitution. Thank you.
Thank you so much, ma'am. Now I will request Dr. Pradeep sir, Dean School of Law, to propose the vote of thanks.
Thank you, Ms. Shivangi. Thank you, ma'am. It was mind-boggling to say the least, and there can't be a more fitting tribute to Dr. Ambedkar than having you summarize the Constitution in such a nice way. And close to 300 participants were participating in your lecture, and that is another testimony of the interest of the student primarily in faculty. And you are having a class at 10:30. Otherwise, we would have stressed it for longer period with a lot of question and answer. But we will have you on the campus so that we can have lively discussion and your knowledge can guide the future legal professionals. I, on behalf of the faculty, student management, and all the participants, pay my deep regard to you for your such a sound knowledge. If I had to summarize your lecture, I'll need another half an hour at least. So thank you very much, ma'am, for taking out a precious time. And I'll request that you please visit our campus for at least half day so that we can have long discussion because there are many issues which could not be touched like fatigue of democracy and Capitol Hill being captured. Then India also facing certain issues, underlying issues. So we can discuss them during your next interaction with us. We have sincere regards and big thank you to you, ma'am. Thank you very much.
It will be my pleasure, and thank you for this.
Thank you.
Thank you.
Thank you so much, ma'am. Thank you.
Good morning, ma'am.
So, do I just hang up? That's what I
Yes, ma'am.
Yeah,
You,
okay.
you may leave, ma'am. If you have time, you
Ma'am,
Ma'am, do you have one moment if you can?
Yes.
ma'am,
Saying something? Maybe a minute or two because I have a 10:30 class. Maybe
we can leave, ma'am, so that ma'am can prepare for her class. Next time we will request
Thank
ma'am to
Ma'am,
spare.
Okay, thank you.
Thank you, ma'am. You may leave, ma'am. Thank you, Dr. Avinash.
Thank you, sir.
Wonderful,
Thank you, sir.
wonderful tribute to Dr. Ambedkar. And she is such a erudite speaker, such a deep
Yes, sir.
command over
Yes,
Constitution.
sir. Yes, sir.
Wonderful. Thank you very much.
Thank you. Thank you so much, sir. Thank you,
Thank you.
sir.